What is a negotiated plea in Cook County Felony Court?
I mean, negotiation is by definition, it's the state will, again, they will offer your client a plea offer, and that is not set in stone. We come back and say, well, how about shaving off a couple years? If maybe we're talking about a probation deal, well, they gave us a probation plea offer, but there's, you know, a number of conditions, and we think it's a little burdensome, a little unnecessary. We might be negotiating the conditions of probation if it's a probation type case. If it's a case that they're talking incarceration, perhaps it's us counter offering as to a lower sentence, or even down to probation and saying, this is why we believe our client is worthy of it. Here's the issues with your case. And so it's our job as defense counsel to put together a compelling argument when we're negotiating to a prosecutor. It's not as simple as saying, hey, I don't want that, can I have this? We got to bring facts to the table why we think our client's deserving of it, you know. And so if the state is gave you a plea offer of 7 years, maybe we come back and say, we think 3 years is more appropriate, and here is why. Here is the things that our client has done. Perhaps it's a 5th, 6th time DWI. Well, he's been sober for X amount of time. He's gotten treatment out in the community while he's been out on pretrial release. And so those are things that we will bring to the prosecutor to help lower that sentence and mitigate it.
I mean, that's an important fact, like understanding what those are to mitigate a plea reduction of some sort or bargain.
It is, and it is incumbent on us. And I think a lot of defense attorneys ignore this aspect.
Right.
For instance, if I get a client out on pretrial release in Illinois, in Cook County, and let's say it's a felony dope case, it's a felony drug case. Well, I don't want him just being out and about. What I want him doing is getting treatment. You know, maybe a year passes while this case is pending in the judicial system, and at some point I want to go back to the prosecutor, or perhaps it's at sentencing, and say, while he's been out on bond, he has been in inpatient treatment, intensive inpatient treatment. He has continued to go to AA or NA and done all these things to better himself or herself, so we can put together a compelling presentation to lower that sentence. I think too often defense attorneys ignore that aspect. For instance, recently got someone pretrial release on a sex case, and immediately had a meeting with the client and his family to get him enrolled in a number of things relative to the crime, a psychosexual analysis, intensive therapy, so we can bring these things to the table. At some point when we're negotiating a plea, or again, if it's at sentencing in front of a judge, we're saying, look at all these things our client has done to better themselves. And so step one, getting our client out, but step two immediately is let's figure out some things we can do to help mitigate this if it's necessary in that particular case.